All right, if you've got a constitutional law exam coming up, you absolutely need to get your head around the power struggle between Hong Kong's top court and Beijing's main legislative body. In the next few minutes, we're going to break down the landmark case that really defined this entire relationship and what it all means for one country, two systems.
So here's our roadmap. First, we'll set the scene with these two clashing legal worlds. Then, we'll meet the two main players and look at Article 158, the rule book that was supposed to manage them. And finally, we'll get into the big one, the case that blew it all up and created a whole new constitutional reality.
Okay, so let's get right to it. The whole issue really boils down to the basic law. The best way to think about it is as an interface, right? It's this document trying to plug two completely different legal universes into each other, all under this one umbrella of one country, two systems. And this is where you can really see the problem. On the one hand, you've got Hong Kong's common law system. It's all about independent judges and courts that can literally say, nope, this law is invalid. But on the other hand, you have the PRC's system. There, the top body, the NPCSC, interprets law with political goals in mind, and no court can tell them they're wrong. You can already feel the tension, can't you? So who are the main characters in this constitutional drama? It really comes down to two heavyweights. In one corner, you have Hong Kong's Court of Final Appeal, the CFA, and in the other, the Standing Committee of the National People's Congress, or NPCSC. Now let's zoom in on the NPCSC, because this is super important, especially if you're a law student. You have to get this. It is not a court. It's the core of China's state power, and it wears all the hats: legislative, judicial, you name it. And here is the absolute key takeaway for your exam. When the NPCSC interprets a law, that interpretation becomes the law. And that brings us to a concept you have got to wrap your head around: legislative interpretation. Think about it this way. Common law judges are like legal archaeologists, trying to uncover the original meaning of a law. But legislative interpretation? That's totally different. It's about shaping the law to meet a policy goal, even if that means changing its meaning. It's a tool of state power. So you've got these two powerful players with totally different ideas about law. How on earth does the basic law try to referee this? Well, it tries to, with Article 158. But you'll see pretty quickly that this wasn't a clear rule book so much as a constitutional minefield, just waiting for someone to step on it.
Okay, so let's look at the first part. It seems super straightforward, right? It says the power to interpret the basic law belongs to the NPCSC. Full stop. Seems pretty clear who's in charge.
But of course, it's never that simple, is it? The next parts of the article give Hong Kong's courts a job to do, allowing them to interpret laws that are within the city's autonomy. But here's the catch, and it's a big one. If a case touches on Beijing's business, the top court must ask the NPCSC what it thinks. It creates this complicated system with a very fuzzy line right down the middle. So you can see the problem brewing, can't you? What happens when the two sides look at the same issue and one says, this is my job to interpret, and the other says, no way, it's mine? Who gets to decide? Well, that wasn't a hypothetical question for long. It all blew up in 1999 with a case that became an absolute landmark: NPCSC v. Director of Immigration. This wasn't just another lawsuit. This was the first full-blown constitutional crisis. So, what was this all about? At its heart, it was about families. Specifically, kids born on the mainland to Hong Kong parents. Now, the basic law seemed to say they had a right to live in Hong Kong. But the government passed another law saying they needed permission from the mainland first. So, naturally, the families sued. And this is where things get really wild. In its ruling, Hong Kong's top court says something absolutely stunning. It claims the power to review acts of the NPCSC itself to see if they follow the basic law. For you law nerds, this was Hong Kong's big Marbury v. Madison moment, a massive claim of judicial power. So the big question was, did the court have to send this up to the NPCSC for an opinion? Well, the court created its own two-part test to figure it out. First, they'd ask if the issue was about the central government. Then, they'd ask if an interpretation was absolutely necessary to decide the case. And here was the clever part. They said they only had to refer if the answer to both of those questions was yes. So, applying its own test, the court said, look, the main thing here is the right of abode, and that's squarely on Hong Kong's turf. So, since the first condition wasn't met, they decided, we don't need to refer it. Bam! They then went ahead and struck down the government's immigration law as unconstitutional. You can probably guess what happened next. This decision didn't just make waves, it caused a political earthquake. The government panicked, thinking there'd be this huge flood of people from the mainland, and decided they just couldn't accept the court's ruling. This was the opening for the NPSCS to step in.
And things moved fast. I mean, really fast. Just months after the court's judgment, Hong Kong's leader did something totally unprecedented. He went around the courts and asked the NPSC in Beijing directly for its take on the law.
And the NPCSC's interpretation? It was the exact 180-degree opposite of what the court had ruled. The court said the right of abode was absolute. The NPCSC said, no, it's not. It's limited by this other article. In effect, it was a total override of the highest court's decision. So, how did they justify this? They said the Hong Kong court just didn't get the legislative intent. And their proof? They pulled out some old documents from before the handover. Now, for any common law student, you know that relying on that kind of stuff is, well, it's just not how it's done. It was a completely different way of looking at the law.
So there you have it. The NPCSC had laid down the law, literally. The ball was now back in Hong Kong's court. How would the judiciary respond to this flex of ultimate authority? This led to another case, a case that would set the new rules of the game for good.
That test came in the form of Lao Zhengkong, and it boiled down to one huge, profound question. Is an interpretation from the NCPSC legally binding on Hong Kong's courts, even if it completely contradicts their own final judgment?
And the answer, coming from the Chief Justice himself, was a clear and total yes. This quote right here is everything. The court admitted that the NPSC has a plenary power. Now that word plenary, that's a key term for your exams. It means absolute, complete, and unrestricted. The court was acknowledging that its power was not in fact final. Okay, let's boil this all down to your exam revision. Here's what you need to remember. 1. The NPSC has the final and absolute power to interpret the basic law. 2. This power is plenary, meaning they can use it whenever they want on whatever they want. 3. Their interpretations are binding and basically tell the courts what the law has always meant. And 4. That bold two-part test the CFA came up with in NK Ling, yeah, that was effectively dead on arrival.
And all of this leaves us with a really big, lingering question. The Ninka Ling saga established a clear winner in this constitutional power struggle. But what does that precedent truly mean for the promise of an independent judiciary, for the two systems part of one country, two systems? That's not a historical question. It's the central constitutional question that Hong Kong is still grappling with today.